Hello, my name is William Wessner. It is April 9th, and I'm telling you about a case, CR 2021-0310. It's an aggravated assault with a deadly weapon, disorderly conduct, fighting. Even though I didn't get into a fight, it goes from there. So we move forward. In November of 2021, I was charged by mail in Apache County, even though the constable knows who I am, and they actually talked to me many times because I had several harassment cases. The court knows where I live because I beat those harassment cases, and I had to give my address to the court system many times because we have P.O. boxes here, not physical addresses. Apache County decided to mail it to Apache Junction, which I've never lived at, never moved from, and never been there. They decided that that was the case that they needed to do, so they couldn't notify me of my original court date, which was December 1st, 2021. I called up and hired a lawyer, and then they moved the case to January 11th, I think. We had a contested preliminary hearing. We did the contested preliminary hearing, and they found probable cause, so we did an arraignment, and I asked for my jury trial according to the rules of criminal procedure. The judge acknowledged this on the court transcripts and never scheduled it. Judge Latham, I believe it was at the time. So we move forward. In August of 2022, August of 2022, we filed a motion asking for a jury trial. Nothing was ever done. No waiver of time, by the way, at all. In February of 2023, I was arrested for first-degree murder. Then it was conspiracy to commit first-degree murder, and then it got dropped to an attempted first-degree murder, where I was the primary and the conspirator. It gets kind of crazy, but we're talking about the 0310 aggravated assault case. So we had a bail hearing. I wasn't allowed bail because supposedly I was on felony release and I was on pretrial restrictions on the 310 case. Even though there was no court-ordered documents, Judge Whiting at the time ordered that he believed, or he said that it was the defense attorney's responsibility to order pretrial restrictions. He told Ron Woods this, it's in the court minutes, that it was his responsibility. And because this is my first felony I've ever been charged with in my life, we're now at this crazy stage, and I didn't know anything. So I'm in custody, I'm in jail. I get filed with a harassment case, civil, which is really interesting that I supposedly killed somebody, but I never killed anybody. Not in these events, not at all. The victim was never touched. I never even approached her. I actually avoided her because she was a Karen and liked to have a lot of problems. And she usually made them up. And she works very hard at trying to smear anybody and everything. She loves the rumors. But we move forward. I asked for a hearing in that, didn't get one. The court, Judge Gunnell's court, refused to hear it. I wrote them several letters. They said they never got them. It's amazing when you're an inmate and you try to write letters, most of your letters never make it out. You never get a chance to, you give it to the guard and it disappears. They blame the post office blames the sheriff's department, and the blame circle goes round and round. But most of your letters never leave or get to where they're supposed to go. But that's another case for another thing. We move forward. We have hearings on this aggravated assault. Well, it was actually largely ignored. The aggravated assault case was largely ignored. Every month that I went to court for the murder and the aggravated assault, even they said they were separate, but they wouldn't separate the cases or separate the hearings. So I have a paid lawyer at this time. In June, we file a motion for dismissal underneath Rule 8 because it's 180 days if you're not in custody, and it's 150 days if you are in custody. They have to bring you to trial. At least that's what the rules say. The rules of criminal procedure do not apply. They're arbitrary guidelines, I guess, or things that the judge can go, yeah, we don't really care about them. And that's the rule of law in Apache County. Because if you have a fuck Joe Biden flag, you don't, that's attempted rape of the President of the United States. Because words alone, according to Judge Garrett Whiting, constitute a crime. Even though that's not what Arizona statutes say, it's not what Arizona rules say, none of that it applies. It's kind of weird. It's funny because they do all of this to get you to take a plea deal. They use while you're in custody to coerce you into a plea deal. So we move forward. We're in June of 2023. This case, we file a motion for dismissal, show the prejudice. The judge rules against us not because my motion has no merits, just because the county instituted an illegal administrative order, 001, that states that unless both parties certify that they've received everything. Now, mind you, the district attorney's office has turned over no discovery from the November 2021 charges. Now, most of the discovery was my video, by the way, and police interviews, but which go into crazy, absurd thing like my Facebook posts, and I have Facebook memes that are directed at people that aren't even part of the case. We have other Karens involved that and that's a a DPS's wife, and she thinks that she wants to be a victim, so she tries very hard at it. Unfortunately, she couldn't be a victim because I didn't even know who she was. I had like 3 interactions with her my entire life. And she's kind of I personally don't think that she's mentally stable. So, anyways, we move forward. I didn't remember who she was, and my interactions with her are just insane. She thinks I looked at her boobs when I never seen them, and I don't care to. I never tried to, never wanted to, never asked, never had access to any video that showed her boobs. I didn't have anything. But that was another accusation that she tried to pile on as a feeling against her. She also said that I abused her dogs too, which anybody who knows me, I don't abuse animals ever. But we're going back to the aggravated assault case. So we file a motion, the state refuses to respond. The judge rules against me by that because of the administrative order stating it has to be certified. So they made up an arbitrary rule. This rule did not follow the rules of local, getting a local rule according to the courts. They never went to the Chief Justice of the Arizona courts to get approval for this. They never posted it for 30 days online for open public comment, nothing like that. So they just imposed a rule, said this is what it is in Apache County. Now, none of this was ever furnished to me. It was furnished to my lawyer. It just, for some reason, it never went anywhere. So we certify that we've whatever, and in that motion that we certify it, we put in there that now this is June of 2022, almost a year beyond the charges, and in violation of the rules of criminal procedure because the state must turn over evidence. Now, I've been told that the county, the prosecutor's office, or county DA's office, whatever you want to call it. I call it the DA's office. I've always been in a city, it's not county DA's office. But never turned over any witness lists. They never turned over any evidence, turned over nothing. Zero. So they set it for a trial date. In July of 2023, the state decides to turn over part of the information. Most of it is my dashboard cams and the video from the bar that shows that I didn't touch this guy and I came only within 6 feet of him, stopping without skidding, without kicking up dust, without coming in at 60 miles an hour, but a high rate of speed is now 20 miles an hour, approximately. Now this is from an uncalibrated, unregistered GPS unit that is a cheap Chinese knockoff that when you watch the video, and if you want to see the video, I can post it or give it to people, that shows that I stop at a stop sign and the GPS is still registering 11 miles an hour. So it's not a very accurate representation of speed. And that was told, that my defense attorney was told that he wasn't allowed to bring that up, or he didn't want to. I'm not sure what was going on. I wasn't allowed to talk to that defense attorney. So that's June. In August, they file a motion to remove my lawyer, as even though it's set for a trial date in October. And he filed a motion because I had ran out of money. I've been in jail for way too long, and I'm just out of money. I had nothing. What do you call it? They grant his motion under the fact that he's going to testify against me. Because supposedly I had threatened to kill the judge and the district attorney while on the phone in the jail. The only problem is that the district attorney has no jail recordings of my conversations that indicate that I threatened to kill the judge or the district attorney. So their idea that the investigation is inconclusive, but they want to bring it up and use it up against me, that is prior bad acts. So they want my lawyer to testify against me. The judge agrees to this in August of 2023. So I get appointed John Lee. John Lee comes to me and talks to me in the bathroom and tells me that they're offering a class 3 solicitation for murder, and that they're going to drop the aggravated assault to disorderly conduct. Very good deal. I said, have you looked at the evidence? He goes, no, I don't need to. This is a really good deal. You need to take this plea deal. I said, no. Well, then we went to court on September 11th, 2023. I really wasn't present for it because I didn't even get a chance to sit down. The judge and John Lee had already prearranged, even though I told John Lee that he didn't have the right to waive my time until we had a chance to sit down and talk and go over the evidence. And that I could sit there and explain to him what's going on, because I was on the phone with the sheriff's department. Now, that 911 call got deleted. The lady who made a phone call at 911 that I drove into at 60 miles an hour didn't get deleted, made on the same day at the same time. Even though her audio is in complete contradiction, and all of her statements to the police, by the way, which is usually obstruction of justice, are contradicted by the video, including the one victim, but then they added another victim. Both of theirs are contradicted by the video. So you know that they're lying, and I can show all this too. I have no problem with that. But that's the narrative they wanted to believe, because $42,000 got paid to Michael Whiting underneath a political donation from this lady, what was later stolen from my truck when I was arrested by murder by Joshua Polk. The papers just disappeared, and I'm unable to get public access to it again. So as you can see, more corruption. And by the way, the county does not care about FOIA acts. They will openly defy all FOIA because there's no punishment for them. They have no bearing whatsoever on FOIA. So, and they usually destroy the evidence, screw it around, not give it to you within time, even though you have time frames, and then the courts won't grant you. I've seen that happen too, extra time to get it. Even if you have a lawyer, they'll just openly sabotage you. But that's something else for another video. So here we sit, and I get appointed John Lee. He tells me I need to take a plea deal, 5 years probation for first-degree murder. That's a good deal, right? Only if you hurted somebody. According to the rules of witness underneath the Arizona, the victim, in my case, wasn't even allowed to testify because she had no direct knowledge of the events that supposedly happened that would have done for the killing. And she kept showing up in court. So there was no murder, there was no attempt. She even admits that I didn't attempt anything. But I got arrested for supposedly a conversation that happened outside of her ears and outside of everybody else's ears, but it didn't happen. And both people that were in the conversation testify that that wasn't the conversation. And the conversation never happened. But that's okay. That's first-degree murder or attempted murder. So we go forward with that. I'm not even on the attempted murder stuff. So now we go back to the aggravated assault. So I get a plea offer. I have to take one with the other. I was considering taking the disorderly conduct for the aggravated assault just to get to the murder charges so I could get out of jail. They said, nope, you have to take both. And I would have had to leave the state of Arizona. That was part of one of the plea agreements. I have to leave Apache County and leave the state, which is interesting. So as we move forward, we had another court hearing. I tried to write John Lee. I tried to call John Lee. I tried to communicate with John Lee. He refused everything. Then I found out he was working as a prosecutor in the downstairs court, and in the upstairs court, he was a defender. If you want to get a good plea deal, he usually does a decent job at getting plea deals. Everything else, don't ask him to do, because John Lee won't do it. He is not there to represent you. He is there to get a plea deal and kick you down the road. And that's it. Any type of argument he doesn't want to make, doesn't want to have, and he'll just let you sit in jail until you decide to see things his way. And that's usually the options that you're given when you're in jail. Take the plea deal or sit here and rot until you decide to take the plea deal. And they don't move it forward. They don't do anything else with the cases. So there is a conspiracy between the public defenders and the prosecutor's office. I don't know about the new public defenders, but I do know the actions of the old public defenders are very much in alignment with the prosecutor. So this is in September. They hold a hearing while I'm in Springerville court for a harassment case that eventually gets dismissed. Because playing music at 11 o'clock in the morning on a Monday is, I guess, not a real crime. But they can charge you with it and hold it over your head for several years. So as we drop back to the aggravated assault case, so they tried to get me to plea, and then I wrote my lawyer. I tried to explain to him what's going on. I tried to break down the video as much as I could remember. Because he refused to talk to me. He refused to see me. He refused to go over my case, refused to listen to my wishes, which is against the rules of professional conduct of his thing, which makes it an Arizona bar complaint. I pointed out to him that he is on the borderline of that. He took that as a threat and then tried to remove himself. The judge told me that I did not have a right to a lawyer and that he could remove my right to a lawyer, that I would have to go pro se and he could force me to, which would mean I'd have to defend myself. Now, I'm not stupid. I can read. I don't claim to be an expert on the rules of professional conduct or the court procedures because none of them make any sense. I don't know how you can have an attempt at something without an overt act. I don't understand how you can have an aggravated assault without ever touching somebody. I don't understand those things. They don't make any sense. So we go forward with that. All I know is that I needed a lawyer who kind of understood my charges. John Lee didn't want to deal with it, and that's just the way it goes. So he asked to be removed from my case after they bullied me into turning over my letters to the court. And John Lee says, well, if he doesn't have anything to hide, he should just turn them over anyways. So I turned him over in camera because he doesn't believe in the constitutional right to just be yourself. Unfortunately, he doesn't believe in the protected right between the lawyer and the client. He held hearings outside of me, and Judge Whiting agreed that they had a hearing, but then he had to backstep it because he forgot that I wasn't there. And then they added in the court minute entry that I was there at that court hearing, even though I was in Springerville dealing with a harassment case. So we go from there. This is in September. So I felt at my lowest, and I just said, fuck it. I wanted out by October 31st. I said, fine. If we had a hearing October 31st, I said, we can do the plea deal. They upped the charges, though. They decided to keep the class 3 felony for solicitation was the plea offer for murder. And then they tried to up it to a class 4 felony for the aggravated assault rather than disorderly conduct. I said, fine, if we can get it done October 31st. Well, Celeste Robertson didn't like the fact that I was saying that I wanted it done by a certain day, so they decided to change and move my hearing and not allow me to do it. So October 31st came and went. I had a hearing November, first week of it. And then I said, no, I'm not doing the plea deal. I said October 31st. We were done at October 31st. And in the process, I found out that I had a constitutional right to a lawyer, and that the judge took away my lawyer unconstitutionally, that there is no way they could have sentenced me to jail time and it would have been immediately overturned. So, unless I willfully, knowingly, and intelligently give up my right, or threaten to kill my lawyer, or try to kill my lawyer, or file over 200 plus bar complaints, because those are the 2 cases that he submitted to me. When I asked Judge Whiting what my actions were that barred me, that got me the warning, he refused that question. He ignored it, and it was kind of great. I mean, it was awesome because John Lee was actually in the courtroom and he had his back turned to me and he wouldn't talk to me. And he goes, well, you need to ask your lawyer. And I said, look, he's not even talking to me. This is a joke. And he goes, well, you need to learn how to be quiet in my courtroom. There's only 2 people that have a right to speak in the courtroom as long as you're not disrupting the proceedings. That's the defense, the defendant, and the victim. Those have constitutionally guaranteed rights to speak in court. This court does not like it when defendants speak. I was never disruptive in his court. And with the public lawyers that they gave me, I actually think they were lawyers for the judge, just my opinion, because there was words and hints that John Lee told me that they weren't allowed to file Rule 8 motions and that the judge forbade them from doing it. So that's judicial interference in a defendant's right to a defense. It's kind of interesting. So we move forward. I got assigned Bryce Patterson. We were dealing with the 404B hearing, so they're trying to bring in other prior bad acts. The only problem is they weren't other prior bad acts. They were future bad acts to this crime. So I supposedly committed this crime in August of 2021, and they wanted to bring in my crimes of threatening to kill a judge that they never charged me with, threatening to kill the district attorney, which they never charged me with and had no evidence of, just a wild accusation. And then they had no proof that it happened, because they were told that it happened on the phone, but there was no phone call that happened. But they wanted to bring these in as other prior bad acts, even though they had nothing to do with the aggravated assault. They also wanted to bring in the attempted murder, even though it had nothing to do with the victim and everything else. Well, at that hearing, nobody knew the way the judge ruled. He bloviated so much at that point that my lawyer had to ask the clerk of courts whether or not it was in our favor or not. Ron Wood, the lawyer that they said was going to testify against me, even though he was never going to testify, and they did it so they didn't have to deal with him as a lawyer. So they removed him as after the trial was already set, which is a total violation of the rules of criminal procedure. But we move forward, and at that point, and this is in November, that they go, oh, nope, you can't do this. And I guess they ruled in my favor. I would have found it funny to have a woman that can't testify at another trial because of the rules of 603. You have to have direct knowledge, and she had no direct knowledge because she was told from a friend who told her from a friend who told her from a friend that I had hired somebody to do something, and this is what it was, even though there was no payment, no overt act, and no action towards the end goal. And I knew nothing about this, and neither did the other person. So it's kind of interesting. But as we move forward, that's fine. That's for another video. And this is in November. So we move at this and going up. And the judge rules in our favor, tells me at a Donald hearing that I can receive 30 plus years, everything can be charged as something of this and that. It was a very confusing, non-straightforward hearing that had so many variables you didn't know what the hell was going on. So they set it for trial in February of 2023. I was told that I wasn't allowed to talk to my lawyer. The judge said that in front. He says, don't expect any phone calls and don't expect to be able to communicate with your lawyer. He said that. It's in the court minutes. That's actually one of the things they got right. The minutes aren't always true. They work hard at altering in changing the perspective of the court minutes, even though these are official records. And they don't do transcripts, they do court audio, so they can delete it later or not provide it or try to hide it. They should really do a transcription. It's just a mess at this county. They work hard at not working, and they work hard at not providing the public with transparency. They are not. There is no part of Apache County government that is transparent. Do a FOIA request on anything sensitive. You won't get it. They don't care about FOIA requests because there's no teeth. They don't go to jail. They don't get punished. They don't lose their jobs. They don't do nothing. They can just say, yeah, have a nice day, go away. And that is the difficultness of Apache County. So we move forward. In February, we have this hearing. I talked to my lawyer 3 days before about my case, the trial. Not a very effective communication because he's already got it set in his head what's going on. And when I tried to bring up about the property lines and pictures, he said, yeah, no, I was told I'm not allowed to bring that in. At the trial, there's a lot of things that he didn't object to. One, he got forced into because I was become very squirrely about the police officer, Andrew Arona, changing his testimony from his preliminary hearing, and Celeste Robertson justifying it, saying, well, you weren't really prepared for the preliminary hearing, were you? And Andrew Arona admitted that he violated ACSO policy. Now, ACSO, Apache County Sheriff's Office, has taken no disciplinary actions against Andrew Arona for changing his testimony without filing a supplement according to their policies. Think about that. He supposedly didn't notify anybody, but he notified Celeste. We all know that because he was her investigator. So the investigator is actually part of the district attorney's office, and they have a duty and requirement to turn over all discovery. They chose not to disclose this discovery. So there's another court procedure violations, and the court doesn't care. Judge Whiting works with the prosecution on trying to railroad people into convictions. So we tried to do the defense of premise and the defense of property, 13407 and 13408. I was told I was not allowed that, even though the evidence in the slightest degree. And the reason why I went there was because I got notice of criminal trespassing and criminal damage to my property. They had hit my food trailer. Andrew Arona actually testified that they reset and they moved over, even though the video shows that they never reset and they never moved. My lawyer refused to play that video and to refute this guy's testimony. I found out later on that the judge had instructed him that he wasn't allowed to do certain things. It's kind of a mess. So as we move forward, Mr. Patterson removes himself from my lawyer. I get Mr. Brewer as my lawyer. We have the murder case going forward. This is in February. April passes, and then we get to May. In May, I do the sentencing, and I get sentenced to 1 year in county jail and 5 years probation. My first felony in my life. According to adult probation, it was a dangerous crime, and they wanted me to do 15 years for my first offense in Apache County. I know people that have gotten 24, 25, 26. One guy had 52 felonies in Apache County. And he was only serving 5 years, and he was charged with aggravated assault, attempted murder, and a bunch of other stuff. It was insane. And so here it is, and most people who get aggravated assault, the plea deal usually comes down to time served, 5 years probation, including if you beat your girlfriend with a pipe while on fentanyl, drunk, and on spice. There's other things that you can beat each other with a piece of gravel and you get less time than what I did, which I never touched my victim. Never. But he's traumatized. So I'm not even going into that. So I asked for an immediate appeal. I get assigned Penrod. He finally gets the chance because the court decided to postpone several times, turning over all the court documents. They didn't turn over all of them. They cherry-picked a bunch of them. There was some requests to get new ones because they do the court audio and then they have to send it out to transcripts, and everything can become a mess. So unfortunately, Apache County works hard at making this process as long and as difficult as possible. So on the first lawyer, my appellate lawyer, that goes through. Well, he ended up getting appointed to a judgeship in Navajo County. Congratulations. I hope you do well. Michael Penrod is, from what I've seen, is a very good lawyer. He does try his best, and he does communicate with his defendants. He actually tried to do the best he could for a lot of people. I understand it's a bad situation, and there's things that are beyond their control. But he didn't actively try to sabotage his defendants. So he's there. He gets appointed to a judge. So then they interview me another one, Elizabeth Hale. So I get out of jail. Well, 2 weeks before I get out of jail, she calls me up and says that she got a phone call from the AG's office about my appeal, and that they were going to write a motion to do a reverse and remand on my case, because they agreed with some of the issue, with the main issue, that I wasn't allowed the defense of premises or the defense of property as my rights, as jury instructions. So we move forward there. So I get out, I'm on probation. March 11th, Celeste Robertson files a motion to vacate the charges, not through the appellate division, nothing else like that, just to vacate the conviction, not the charges. So the conviction gets vacated, which is unusual. It's very bizarre, and I've been told that a lot. There's a lot of things that are very bizarre about my case. It kind of goes into the levels of insanity, I guess. So we go from there, and then I move forward, and March 14th they vacate my charges. Conviction, not my charges, my conviction. So then I go to another court hearing, April 7th. I'm told I'm on pretrial restrictions, are the same order from the original case from 2021 is in effect. So when I talk to Elizabeth after the case, I tell her that there is no order, that nobody installed any pretrial restrictions. There's nothing there. And this is on the court record. She goes, well, I'm an appellate lawyer. I'm not a trial lawyer. I said, I understand that, but they said it was your responsibility to impose pretrial restrictions. At least that's what they told Ron. She goes, no, you don't do that. That's insane. She goes, I have no authority to enforce the pretrial restrictions. I said, I understand that. I said, but this is what the judge ordered the last time. We did this in of 2023 when they said I violated the pretrial restrictions. Even though there was no pretrial restrictions, there should have been, so I should have known what they were. So that's why I was held without bail. She goes, that's not the case. Nobody does that. I said, this is what was done. She goes, well, I don't have those orders. I don't have that court transcripts. I don't know anything about it. I said, I understand that, and this is the problem. This is how convoluted it is. So they've done that, and we've moved forward. So now I called pretrial services. Pretrial services says they have no file on me, and that as far as they know, there's no court order that I'm under pretrial restrictions. So I now had to cancel my doctor's appointment in New Mexico for my back and my knee through the VA because I don't know if I'm allowed to leave. I don't know if I'm allowed to go on. This is the confusing events of Apache County. More to come. And I also have more to talk about the murder case and the harassment case and the other charges. And then we have the police corruption. We have the some of the public defenders corruption, at least my personal knowledge of it. And how the Celeste Robertson continued going on about 6 murders that never happened. We have the virtual murders. It was actually quite a big joke. Because supposedly I wanted 6 people dead, so I committed 6 different murders, even though I was charged with attempted murder for one with no attempt. So, and this is the same girl who won a $600,000 contract to be a special attorney for Apache County. Makes you wonder what's going on here at this point. There's probably a lot of things that are really big issues. People ought to look into it. Step up. Have a nice day. God bless. More to come. If you want to, put a message in the contact. I'll send you the video for the dashboard cam. It's I don't understand all this.